Lynnway Auto have done everything they could to cooperate with law enforcement and all investigators. They've been cooperative from the moment this tragedy occurred.
The DA
He is an absolute pillar of the community. Before this accident, Mr. Lamb and Lynnway Auto took every safety measure known in the community and the standards in that industry to protect not only the customers, the unfortunate victims, his family who works on the floor, and friends and neighbors. I don't know why the District Attorney's Office chose to charge Mr. Lamb and the company with this terrible accident. I can't understand why they chose to hold a press conference weeks and weeks before the arraignment to invite all of you folks to give a skewed version of the facts. Unfortunately, this case will have to play out through the court, and through that time, there seems to be Mr. Lamb, his family, and Lynnway Auto is deeply saddened by the loss of life in this case. We can discuss more later, but that's all today.
Via Skype, Hank Brennan is a criminal defense attorney both in state and federal courts, an adjunct professor in trial practice at Suffolk Law School. Welcome, Hank.
Thank you, Jake. Good afternoon.
Good afternoon. Okay, listen, we just got a short period of time, but we were in a really critical area there.
A first in Middlesex County. The district attorney has just charged a company and its owner with manslaughter after a deadly crash at an auto auction in Billerica killed 5 people. A Jeep barreled through a crowd at that auction back in May of 2017.
The district attorney says that the company failed to fix the dangerous setup of the fast-moving auction floor after a previous incident.
After an incident in 2014, the owner agreed to make changes to create more separation between the cars and people inside of the auction house. The DA says that did not happen. Each of the 5 manslaughter counts handed down today are for the 5 victims killed during the tragedy. That corporation, Lynnway Auto Auction of Billerica, and its owner, James Lamb, both being indicted today on 5 counts of manslaughter. The charges coming nearly 2 years after the tragedy. The crash claimed the lives of 5 people and injured numerous others.
Okay, taking a lunch break. This is something else. It's a grilling.
The owner of the Lynnway Auto Auction pleaded not guilty today to charges that his company's mistakes led to 5 deaths.
Prosecutors have charged James Lamb with manslaughter for the deadly crash that they argue could have been prevented.
The prosecutor's statement of the case goes back to an OSHA inspection 3 years before the tragedy. Federal inspectors found no barricades or protection separating pedestrians from moving vehicles. Employees operating the vehicles were not trained, and operators did not have driver's licenses. Prosecutors say Lamb signed a certified agreement promising to fix those problems, and then this.
Motor vehicle accident, car gets a building.
5 people killed.
Mr. Lamb and Lynnway Auto took every safety measure known in the community and the standards in that industry to protect not only the customers, the unfortunate victims, his family who works on the floor, and friends and neighbors.
Today, dealers attending auctions here say it's a safer place.
Every auction in the whole world runs the same way, just they happen to be unlucky, that's all.
And if convicted, Lamb could face a maximum possible 20 years in prison per charge. That adds up to 100 years.
The Commonwealth has a new special prosecutor in the Karen Reed trial, and we're getting new insight on Hank Brennan from his former legal partner. He spoke with NBC 10's Eli Rosenberg.
The verbal gymnastics that counsel engages in
when the lights shine the brightest
to distort reality is extraordinary.
Like Tuesday's high-stakes hearing in the Karen Reed case is when those who know Special Prosecutor Hank Brennan say he brings his best.
Hank is so successful because he's unflappable. Was there an eyewitness? No.
J.W. Carney Jr. has seen a lot during his time as a lawyer, including working with Brennan when both represented James Whitey Bulger more than a decade ago.
Hank is calm. He doesn't yell at people. He doesn't try to trick people. There's almost nothing he overlooks. In Whitey Bulger's case, he had file after file after file for witnesses.
The Bulger trial bringing with it a crush of media.
I'm very proud of our team.
The Reed case coming with similar interests.
I know Hank was delighted to handle this case. He had watched it a little bit, like we all did, and so Hank is coming up with ways that he will cross-examine witnesses that will really unravel their stories if they're lying.
But I care that it's unfair, imbalanced, and hidden.
Brennan's attention to detail was on display last week. Brennan using a pretrial motion hearing to call into question the use of accident reconstruction experts by Karen Reed's defense.
The Commonwealth just provided the court with information that causes me grave concern,
leading the judge to halt the hearing. It all an example, Carney says, of Brennan's approach to this case and every case he handles.
Hank's attention to detail will be a great help to him during this trial because he will not only have read every document and thought about every document, but responded to defense claims in a very powerful way.
And one more interesting note, you'll of course remember Karen Reed's first trial lasted some 9 weeks, prosecutors calling 68 different witnesses. Not so on the prosecution side this second time around. According to Carney, he says Brennan's style is more direct. He only calls the witnesses he needs to help explain and state his case. Live in Dedham, Eli Rosenberg, NBC 10 Boston.
I'll defer to my counsel.
Jay Carney and I showed up in June after looking at this case and working on it for some time, and we thought we were going to expose a little bit of government corruption. Little did we think that the government would expose more corruption than we ever could have. During that time, from the bottom all the way to the top, you saw the government bring out witnesses that had deals, life, money. And so at some point, hopefully this case is the beginning where people reflect a little bit on our government, ask our government questions about what is going on today.
He ducked and weaved and he weaseled out of the question, but I suspect that there's going to be a lot of follow-up on that issue.
Jim Bulger was very pleased at how the trial went and even pleased by the outcome. I don't think he expected that 9 times the jury would come back and say not guilty or not proven. It was important to him that the government corruption be exposed, and important to him that people see firsthand the deals that the government was able to make with certain people. With that as what he was looking for from a trial, he's very pleased. He has a strong feeling that he should have been able to present his defense, but presenting his immunity defense was only one of his goals in this trial. It's rare that you can achieve all of your goals, and so the fact that he was able to highlight the corruption that he was in the middle of, as well as the corrupt, obscene deals made with certain witnesses, should be something that informs all the citizens about what happens behind the scenes.
The government pinned their hopes upon witnesses who we thought had an absolute lack of credibility, an extraordinary motive to lie, and were not guides that a reasonable person could follow. To ask a public or a jury to trust in whole witnesses that had such promises and inducements and such motives to lie, in some ways that's reflected itself in the verdict.
I'm proud of what Hank Brennan and I did in this trial, what criminal defense lawyers do every single day in this court and in the state courts. We defend people against criminal charges, and we do the best we can.
This trial, while it tells quite a bit about the criminal justice system and the corruptness in the Department of Justice, it doesn't begin to tell the whole story. I don't think you've heard the last word from James Bulger. The depth of the corruption within the Department of Justice in that time, all the way to the top, is a story that should and hopefully still will be told. And so while there is a limitation in this trial on the relationship that James Bulger had with the Department of Justice, that doesn't mean it didn't happen. And so hopefully the public will have questions.
I think the local rule that prevents contact with the media and others once a trial begins is overly restrictive. They would have seen things that would educate them about the federal government, that would amaze them, shock them, appall them, and just make them realize there has to be changes. It's incumbent upon lawyers to be able to come in front of the courthouse and speak on behalf of their client. It's very frustrating, and I hope that the rule will be changed. The government will offer people, in essence, bribes, not by money, but by something more valuable, freedom. And if they offer enough freedom to certain witnesses, I guarantee they will say anything, whether it's the truth or not the truth. He was allowed to be the leader of the organized crime in Boston for 25 years because law enforcement was corrupt.
When I say the name Whitey Bulger, you think mobster, murderer, extortionist, informant. We have heard so much about this man, but we have rarely heard from him until now. Tomorrow, a CNN Films documentary will make its world premiere at the Sundance Film Festival in Utah in Whitey, the United States of America versus James J. Bulger, the gangster who is serving 2 life sentences for his part in 11 murders, speaks for himself.
And now this morning, Bulger's attorney is pointing the finger at the Federal Bureau of Prisons, saying they turned his life sentence into a death sentence.
There are a couple of things I wanted to ask you about.
Sure.
The first is that you've told me since the very first day I met you that you've never been an informant.
That's correct.
Does that mean you've never been an informant in your entire life?
Never.
This morning, a violent end to a turbulent and criminal life. The notorious Boston gangster Whitey Bulger, who had a role in at least 11 murders, killed in a West Virginia prison, found dead at 8:20 Tuesday morning, just hours after he had been transferred to the prison.
Our objective in this trial when we started was transparency and to try to find the truth. And Jay Carney and I discussed strategy weekend after weekend, and we knew coming into the trial it was important. It was important for the jury. It was important for the community. It was important for the public to know how the federal government operated during that time and how they're operating today. So when we approached this case, it was important for us to get as much information to the public and to the jury as we could to demonstrate what happened, why it happened, and ultimately who is responsible. We mentioned that there's a ledger, accountability. Accountability doesn't come down to one person. Accountability is everybody who had a hand or a role in the carnage that lay behind what happened during that period of time. Jay Carney and I talked regularly. We felt the presence of families and victims and people left behind. And it was a unique opportunity that we could cross-examine witnesses, attack the untruths, and to be as bold as we could during this case to get answers for people that have deserved answers for decades. People who have been deprived of the answers about what happened to their loved ones and why it's happened. The answers to who is accountable and who's responsible.
Whitey Bulger is dead.
A chilling, violent end to a murderous life.
I hope it was a brutal murder instead of a natural cause.
A force of evil who created a reign of terror.
But that guy put my family through hell and back.
Ruling the Boston underworld.
Thank God. So,
and orchestrating countless cold-blooded killings.
What did Whitey do to your family?
Destroyed it.
Notorious gangster James Whitey Bulger killed behind bars.
The world is a much better place and a safer place without Whitey Bulger in it.
That's why we called members of the FBI that the government chose not to call, people we had never even spoken to before, to get them on the stand and try to find out answers. That's why when we cross-examined witnesses, we didn't shy away from areas. We wanted to know We knew the community wanted to know, and we knew that many of the victims' families had to know. And we did our best. At many points, we were stopped over and over again. We were prevented from bringing out information that our members of the public, our citizens, are entitled to know. And so that's why we say today, really, for us is the first step. There's another chapter to be written. There's more accountability. And our government needs to answer the hard questions that have been raised by this case. There are answers that are needed by the families and the public that the families and the public need to keep pushing for. And so we've tried our best, and we'll keep trying the best we can. And now it's time for the public to try as well.
Hypocrisy. Really, the history of how these hearings have progressed has changed dramatically over the last decade or so. And
we talked a little bit about some of the hypocrisy that goes on by both sides in these hearings, and it is unfortunate. That's very different than what you do as a judge. You may do things as a prosecutor. We're in the executive branch of government. I can do it because the law says I can. Unconstitutional. There's not a contradiction in that. Mike, what do you think about that?
I think it's a great point you're making, because people are failing to realize you're talking about him as an attorney. We're advocates. We're not judges. Someone calls us. We're ethically obligated to put forth what our clients want us to do.
Even if it's a fishing expedition and they may find something, although maybe unexpected, that could stall things, it is their hope, I believe, to try to extend these hearings past that time when they could actually make a difference, because now they're simply really powerless other than to voice their objection about stalling his nomination.
Yeah, if I were advising him, I'd be saying, give him the documents so it doesn't besmirch him.
Well, I think he handled it in a very savvy and political way. He takes a very objective position, distances himself without demeaning the people that he was tied to for years, and tries to make clear through the obviously softball question that he has no involvement in something that may be seen as a negative, cast a negative light on him. I think his answers are very smart. His answers are very political. He's not going to take a side or give us any real insight. He's going to have to defend certain attachments he's had with past decisions and associations, but I don't think we're going to hear any depth of attachment to a negative light.
You become that individual person once you get there.
Yeah.
He's not there yet.
Yeah.
And I think he's doing a very good job of, really not answering the questions in detail because he doesn't have the details.
Hank, what are you making of this thing about this false testimony allegation? What is this about?
It's like a good direct examination. The people who are trying to support him are laying out his defense for him. And so they're trying to let him give a more full answer before the question's even asked. And it's a smart move by people who support him to try to allow him to be unequivocal, because when the questions start against him, as you see, oftentimes they're not questions at all. It's simply speeches until the advocate runs out of time. And so this is preparing him for his defense.
Okay, there we go. Now, who says that this can't be sexy, Hank? I mean, he got asked a direct question everyone in America wants to know, and he was ducking and jiving and moving and gyrating. I mean, look, it's a tough question, but I don't know, Hank, what do you think?
This case is littered with problems and fundamental unfairness. Whenever a witness is paid money by the government, not only is it right for cross-examination, but it has to call into question whether or not the person is telling the truth. Imagine a defense attorney calling a witness and paying them a fee to come and testify. The attorney would be disbarred. They would lose their license. And so to hide that evidence and not disclose it not only reflects on the case, but reflects on the prosecution team who's trying the case. It is outrageous that wasn't turned over. And this couldn't be just an aberration or some reckless conduct, because you mentioned the 77 reports. I've had cases where one report has been missing and I find it later and I lose my mind, because the idea of a fair trial is to try the facts, try the information that everybody has access to. So I think you're both right. When you look at this case, it's perplexing that they are trying it again after all this time with these issues that can never really be resolved. You can have legal opinions that allow the defense now to have access to information, but the witnesses' memories have faded. Other investigations they would have conducted are gone. So it really puts the defense in an extraordinary disadvantage at this point.
Yeah, and that's very well said. And guys, listen, I mean, I am a prosecutor at heart, assistant prosecutor for many years trying murder cases, the head prosecutor, and I would tell my staff all the time when I was the boss, as we were trained, Mike, when we were young assistant prosecutors, don't ever let us hear that you withheld exculpatory information or Brady material, as they call that. I used to just open up my file to the defense before I tried a case. I'd take all my personal notes out, and I'd say, make sure you have all the data and information in there, because I don't want the conviction to have to come back. And, you know, with all due respect, prosecutors are supposed to seek justice, not just seek convictions. And to me, not only would have I dismissed this case as a judge, I think these prosecutors should be called on the carpet ethically for what they did here. Just my opinion.
I think the difficulty with the prosecutors is they don't have an eyewitness to say somebody saw this accused commit the crime. So they're trying to put together and cobble together as many witnesses as they can to get the accused close to the crime, whether it was before the crime, after the crime. And so the proximity is what they're trying to establish. And it's something they need to do because they have that absence of an actual eyewitness or scientific evidence like DNA.
This is a very, very weak circumstantial case, Mike, which gets to the point of all those reports being withheld all that time. And as Hank is indicating, they're cobbling as many witnesses together, I guess, as they can to show that he's got some proximity. But you know, and let's talk to our audience about the mere presence at the scene of a crime or being in an area is not guilt.
He said he stopped by this house for a few beers. It seems like this was a party house. It doesn't seem like a house that was really a home where the children were protected. Everybody was sort of on their own, which doesn't blame the victim, but what it says is it also opens to the defense that any one of these people could have had something to do with it, because people were coming in and out of his house and partying. I think this was a Friday and a weekend, and it just is, it rings strange to me.
I think that's an excellent point. Hank, what do you think about the idea as a defense lawyer that you'd be arguing, hey, it could have been one of these, any of these other people as well?
You know, and I think our connection's breaking up, so I apologize, but Mike makes a great point. In the point that it's creating third-party culprit. It's suggesting that this could have happened in a number of different ways. There's doubt. So it doesn't have a deep level of thought in trying to cobble these.
Okay, we think we got where you're going there, Hank, but, you know, one of the issues that I think is relevant here.
Hank, I know that you're jumping into the debate here about this case, too, but we've got an old case. Witness memories are probably a bit fuzzy because this happened so many years ago, but there's an awful lot of record in this case.
Records are really difficult to try a case with. It sanitizes the emotion in the case. Jurors watch witnesses when they testify because it's not just the words, it's how a person says things, their memory, the gestures they make. And without that, the records themselves, the transcripts, really hamper the firsthand accounts.
Hank, I'll ask you this. When it comes to trying a case this many times, does it just become rote memorization for people who are up on the stand and less emotional?
Well, that's always the challenge. A couple of things happen. First, it becomes routine at times, and you have to guard against that. Every case, whether it's the same case or not being retried, you have to look at it like it's a brand new case, because it does drain a lot of the adrenaline and emotion out of it. And secondly, when witnesses testify, they seem very concerned about their prior testimony and very tied to it. And there's always the concern or worry that they'll be criticized for being different, that memories change over time or they may not be as exact. So it takes a certain natural ability out of a witness. It hampers them in a way because they're afraid that they may say something different. So they do become a bit monotone at times. They become very entrenched in their prior testimony, and it limits the government's case.
There were many times during the trial, I won't speak for my co-counsel, I'll speak for myself, where an objection was made. I had no idea what the basis of the objection was. And the court made a ruling on that objection, and I had no idea what the court's basis for the ruling was. We would go to sidebar, and the first thing the court would ask the Commonwealth was, what's the basis for your objection?
To make a record at that point.
Oh, I understand, but it's, you know, what's the basis for your objection? If it were that obvious that it could be ruled in open court, we should have known the basis for the objection. I didn't know it.
I agree with that.
And
You should have known the basis for the objection.
Well, I'm hearing it for the first time at sidebar. There were objections made that I thought had no basis in the law or evidentiary rules whatsoever. The objection hearsay, the objection lack of foundation, just standard basic objections. There's no prejudice to stating them in open court. It will move the trial along more quickly. It'll allow my client to preserve her due process rights, and we'd ask the court to change its ruling from the first trial.
Okay, that motion is denied. So the next motion, defendant's motion in limine to prohibit the Norfolk District Attorney and Massachusetts State Police from having juror contact. So we don't need to belabor this. We talked about this before. No one has contact with the jurors other than the court officers. So defendant's motion in limine to prohibit Norfolk DA and Massachusetts State Police from having juror contact. I'll also include prohibiting defense counsel and the media as well. No one is to have contact with the jurors. The court officers are the only ones that have ever had contact with the jurors. So there's that. All right, so now we'll go on to your motion, Mr. Alessi.
May it please the court. In my presentation today, with regard to Dr. Welcher.
No, I was just wondering if you're going to tell me what you're going to tell me and then tell me what you've told me.
Such a bitch.
Do you plan on doing that or are you just outlining it?
I do not, Your Honor.
Thank you. Go ahead.
His style of argument, he's a very, very experienced attorney. He's one of the best. And he lays out his argument for the judge. Your Honor, first I'm going to tell you some background about the witness, then I'm going to go into my argument, and then I'm going to do this, just to give her a little roadmap of where he's going to go. She doesn't like that. And here is the snark. I thought I was snarky. Are you going to tell me what you're going to tell me? Because I don't need to know what you're going to tell me. Okay? Wow. Listen to that again. She was laughing. She was. Like, this is something funny, Judge Cannoni? Is something funny, Judge Cannoni?
In my presentation today, with regard to Dr. Welcher.
Listen. No, I was just wondering if you're going to tell me what you're going to tell me and then tell me what you've told me. Do you plan on doing that or are you just outlining it?
I do not, Your Honor.
Thank you. Go ahead. And I think we can do it. We need to spend some time talking about voir dire, so I don't want to run out of time for that. So what I plan on doing, give each side 2 minutes. We'll see how we do with that. And we'll try and get through this. All right, so I'll hear you on your motion, Mr. Brennan, and then a 2-minute response. Jimmy, keep track, please.
Yeah.
Section 1105 of Mass Rule of Evidence makes clear that evidence that a third party committed the crime charged against the defendant.
So I will read again the Mass Guide to Evidence. I'm familiar with the law on third-party culprit. Your time is up at this point.
See?
I've read your motion. I've read your memo.
Okay.
Or the pleadings.
Thank you.
All right, Ms. Giannetti. Jim, why don't you stand when it's done? Can you stand when it's done?
Your Honor, I can't do this in 2 minutes.
Well, then we'll hold it. We'll hold it to the end.
That's fine.
All right, Mr. Alessi, I'm going to hold you to 2 minutes. I've got the Commonwealth's motion on the Celebrate demonstration. I'll hear you for 2 minutes on that.
My 2 minutes start when I get to the podium?
Yes.
Thank you.
Given the unusual events that occurred at this trial, statements by witnesses, you can go your entire career as a judge and never face that. Judge not only was always super well prepared for the trial, always very courteous and professional with counsel, but her temperament was one that every lawyer can admire. She was an outstanding judge to handle this case, and we're glad she was assigned it.
Apparently, it sounds to me like it would have been a Brady-type violation where the authorities apparently didn't hand over enough evidence.
It's impossible to have a fair trial when there's police reports and evidence that contradict witnesses. The fact that they found this evidence years later in itself is pretty extraordinary because in many cases it's never found. There can be no real assurance of a fair trial if an attorney doesn't have a right to fully question the witnesses. Well, I'm interested over the next couple of weeks to see if the government has any more direct circumstantial evidence. We've heard a lot of putting a defendant near the scene, trying to tie the accused to an investigation, but it really is a little bit light at this point on actual circumstantial facts, and that's what I think I'll be looking for as I listen.
I am as well.
It's been nice talking to you. Take care.
Absolutely.